Good afternoon. Thank you, Pat, and thank you everyone for joining us this afternoon. We're going to touch on some very important aspects of New York labor law, so I'm really excited that you're here with us today, and let's dive right in. So some of the questions we're going to be talking about today is questions that we get frequently in our practice, and that is entitlement to meal breaks, on-call time, paid sick time, bonuses, overtime, exemptions, etc. We're going to try to cover as much as we can, and whatever we can't, feel free to reach out to us separately. So starting off with meal breaks, we get this a lot. Yes, under New York labor law, employees are entitled to meal breaks. It depends on what kind of worker you are. If you're a factory worker, it's a 60-minute lunch break. If it's a non-factory worker, it's a 30-minute break. Depending on what shift you work, you also will get additional breaks. Now, it's important to realize that you're not supposed to be working. This is in order to be, it's a work-free meal break. So if you are working or your employer wants you to work, or your employer kind of hints like, I really need you to work this lunch, then that's considered work time. And if it goes above 40 hours a week, then it might even be overtime. So your meal break is for non-working. If you are working and your employer knows you're working, then it's time that has to be compensated. Moving on to on-call times. On-call times is when you may be on call, but the employer may not need you right away. So this is an important aspect of the law because a lot of times employers will ask you to be on call, and then in the end you won't be needed, but then they'll say, oh, well, we're not obligated to pay you. So the law says that if the employer made you available wanted you to be available for a specific period of time, and you had to be on the workplace or near the workplace, and the important thing is you were unable to use the time productively for your own purpose. So then that would become compensable. So let's say you are required to work in a factory and you come and for some reason the person opening is late, but you were required to be there at 7. You didn't actually start working till 8. So from 7 to 8, you got to read something or do something on your iPhone. Later, if the employer says, well, you weren't really working for me 7 to 8, then they would be wrong and you would be entitled to pay for that hour because you were there because the employer wants you to do there. The fact that they didn't have work for you, that's their problem. But you were required to show up, you were there, and you could not really use that time productively because you had to be at their workplace. So that would be an example of on-call time that the employer would have to compensate you for. If let's say the employer says, I may need you for a shift midday, I'm not sure, make your own plans Saturday morning, I'll call you if I need you. And that's a closer question because if you really could make your own plans, then you technically could be using the time productively for your own purposes. But if you can't make any plans because the employer says, I may need you, I may need you, then that might be a close call of whether you were able to use that time productively for your own purpose. So the test here is whether basically who was controlling that hour. If the employer was controlling it, he has to pay for it. If he let you control it, then you don't necessarily have to be paid for it. A related principle is called the call-in pay. So there are some jobs where, again, maybe it's a car wash or a babysitting service where some days they need more people, some days they need less people. So let's say if it's a car wash, then the days that it's very nice weather, they're going to need a lot more workers than the days that it's raining. So what the employer might say is, I want you to come in, but then when the employee comes in, the employer says, you know what, it's raining today. We don't need this many people. You're free to go home. When the employer does that, it has to pay you for at least 4 hours because, again, the same thing. You had to carve out time to come to work that day. You maybe had to find childcare. You maybe had to find a babysitter, and you did all that. The fact that once you got there, the employer said, never mind, it's raining, I don't need you. Or let's say in a babysitting service, never mind, we only have 2 kids today, we don't need extra work. Well, that you made yourself available to work. So, and you're relying on that pay. So in those situations, you would still be entitled to a minimum of 4 hours of work, even if you were just there for 20 minutes and the employer said, it's okay, you can leave now, we don't need you. So these are important concepts to keep in mind where the employer needs you to come in, but then says, never mind, I don't need you today. What your rights are in those situations. Another important aspect of labor law is travel time. Some jobs have travel time as an important part of the job. And that might be if it's deliveries, if it's going to a certain site, if you have to drive from, if the worker has two different locations and you have to go from location A to location B, all of that time is considered compensable. The time at the end of the day, if you clock out at 6 and it takes you half an hour to get home, that is not compensable. But let's say at 6 o'clock, the employer said, I want you to just drop off some deliveries at location A and then go home. So the part of the journey that's part of your job, that's compensable. The part that's for you just going home, that's not compensable. So there's a lot of aspects of your job that are compensable that you may not be aware of. Moving on to sick time. So under New York state law, employers are required to give sick time to their employees, depending on the size of the employees, depending on the size of the business. So if it's less than 4 employees, then depending on the revenue, it may be paid or unpaid. If it's employers between 5 and 99 employees, they must provide their employees with up to 40 hours of paid sick leave. If it's an even bigger employee with 100 or more employees, they have to provide them with up to 56 hours of paid sick leave. So if for some reason you are in a business of more than 5 workers and you're not getting 40 hours of paid sick leave, that is something you may want to bring to HR's attention, to your employer's attention, because you are under state law entitled to that sick time. A related question we get a lot is, am I entitled to vacation time? And the answer to that is no. The law does not require private employees to provide either paid or unpaid vacation to their employees. The employer is entitled to make any internal policies, and those might be contractually something that would be binding on them. If they promise their employees, we're going to give you 2 weeks paid leave, 3 weeks paid leave, and that might be something that the employer may be obligated based on their own internal policies. But under the law, they have no obligation to give anybody paid leave. Moving on to minimum wage. As most people are aware, there's a minimum wage in New York. The federal rate is $7.25 per hour. The New York state law is much higher. It's $15 for New York City, Long Island, and Westchester, and $13.20 for employers in other parts of the state. This minimum wage is non-negotiable. You can't say, we'll pay you less. You have to be getting your minimum wage. What's important is that the way New York labor law works is that it has a general rule and then it has these specific industry orders. So it has a wage order for the hospitality industry, which establishes its own rules. So in the hospitality industry, it's an entire section of itself. But if, let's say, you are wait staff or working in the hospitality industry, then technically you do not need to be paid minimum wage, assuming your tips cover the difference. And in order for the employer to get what we call a tip credit, in order for the employer to be entitled to that difference, there are certain requirements the employer has to do. The most important of which is notice. The law is very big on notice because, as we wrote in the beginning, knowledge is power. The employee deserves to know what they're getting, what their wages are, and what their tips are. So if, let's say, the employer is paying less than minimum wage, but it's then paying the difference in tips, it has to tell you that so that you're aware of that rule. And when you see your pay stub and it has less than minimum wage, you understand why. Also, the employer would be entitled to pay you the difference. If, let's say, there was 1 week that the tips were really bad and they didn't bring you over the threshold of minimum wage, you would be entitled to the difference. If the employer doesn't pay you the difference, they might lose what we call the tip credit. And then you might be entitled to damages for all the times that you weren't paid the minimum wage. So again, if you're working as wait staff, you can be paid less than minimum wage as long as you're paid the difference by tips. The tips are very clearly communicated to you on every pay stub. And when it falls short, you're given the difference. We'll talk more about notice a little bit further, but it's very important that you know what you're getting and where your money is coming from. Similarly, the building service industry, there is another building code for people working in the building service industry. So this is for superintendents and janitors working in buildings. There's a specific set of rules governing this employment relationship because the superintendent is typically living on the premises. If the superintendent is living on the premises and he is designated under the law as a superintendent, then he is not entitled to receive overtime. But again, in order for the employer to make use of this exemption, there's a lot of notice requirements that they have to do. So they have to designate their superintendent as a superintendent, and it has to have only one. So the employer can't try to run afoul of the rules and say, oh, I'll designate 3 people as superintendents, I'll give them all apartments, and then I won't pay any of them overtime. That's not okay. Second of all, the employer has to designate the superintendent as a superintendent, and then has to also not give him work in many other locations, because in that case, then he's no longer a superintendent for building A, but he becomes a superintendent. So if he's designated a superintendent in building A, the employer is exempt for paying this superintendent overtime for any building that he covers within 200 feet of the designated building. So if the employer says, oh, I want you to go to this other building half a mile away, that other building is not covered. And the employee would technically be entitled to overtime for work done in that other building. And the fact that the employer confused the superintendent's duties might just defeat the exemption entirely. So technically, if you're a superintendent, you may not be entitled to overtime, but only if your employer follows very specific statutory guidelines. And the same thing is true for farm workers. Workers that are employed on a farm are entitled to an agricultural exemption. Again, there are certain requirements and certain notice that designations the employer has to do. So even though, by and large, everybody is entitled to minimum wage, as you see, there's these carve-outs for different industries, and because of how the industry works, where because of other compensation being given in the hospitality industry, it's the tips, and in the building service industry and the farm workers, it's lodgings and other utilities. The overtime, minimum wage and overtime is different, but again, there are certain requirements that have to be satisfied. In talking about overtime, the black letter law is that everybody is required to time and a half for all hours worked over 40 hours in a week, unless they're exempt. And we'll talk about the exemptions because there's a lot of confusion about the exemptions. The first very, very important rule, and if there's even one thing you take out of today's seminar, it's this. If your employer tells you, I'm not giving you overtime because you are exempt, that in and of itself does not make you exempt. That means the fact that the employer said so isn't sufficient. The question is, what does the law say? So a lot of people will come and they say, well, I'm exempt. My employer switched me to salary 6 months ago and now I'm exempt. The fact that you were switched to salary does not make you exempt. So let's look at what the law says it makes you exempt. There are, the most commonly used one are the administrative employee, executive employee, the professional employee, and the outside sales employee. And that means if under the law you fall within one of these categories, your employer does not have to pay you overtime. So let's take a little bit of a deeper dive on these exemptions. So one of the most common ones we see is the executive exemption. And the reason why we see this a lot is because this applies to somebody who is truly an executive. And what that means, under the law, it's somebody who has 2 or more people working under them. They have the authority to hire and fire, or their suggestions or recommendations as to hiring and firing are considered. They have a certain salary threshold, and they regularly exercise discretionary powers. And these factors are really, really important because, again, unfortunately, you're going to have a lot of employers that are going to make what we call, fake managers and say, oh, great news, you've been promoted to manager. And because of that, now you're exempt. And this employee works really, really hard and they say, I'm exempt, I don't get overtime. But later, when they meet with a lawyer and the lawyer says, did you have the power to, did you have anyone working under you? No. Did you have the authority to hire and fire? No. Did you have any discretion whatsoever? No. And then there's the statutory piece, if their pay was less. So if any of these things are missing, it defeats the exemption. And unfortunately, we have a lot of unscrupulous employers that create what we call fake executive and just make people into managers, but within in the eyes of the law, they're not managers because they don't satisfy these very important prongs. Similarly is the administrative exemption. So the administrative exemption is a little bit similar to the executive. This person does not have two people working under them, but they are pretty high up in the company. They are involved in management and general operations. And a key factor is they regularly exercise discretion and independent judgment. So we one time had an example of, we had an HR director and then an HR, more of a subordinate worker, and both had been classified as exempt. And basically, both were told, you guys are doing administrative stuff. You're both doing HR, that is administrative. But once we looked more closely at the fact, the HR VP was exempt under the administrative exemption, but the subordinate was not. She had absolutely no discretion, independent judgment. Any decision that she wanted to make had to go through her supervisor. And the extent of her management was very, very limited. So again, she was a glorified administrative assistant, but she really wasn't. In the eyes of the law, or at least that was our position in moving forward in litigation, she did not have any of the type of discretion, independent judgment that would render her exempt under the law. So again, you might find that you or your friends are told you're exempt under the administrative exemption. Find out, do you really have any power in this company, or is it just a glorified position? Moving along to the professional exemption. Professional exemption is the one you're going to see a lot, and that is somebody with advanced knowledge in the field of science or education acquired by a prolonged course of specialized intellectual instruction and study. This is why professors, doctors, lawyers are all exempt. This one is pretty easy, and there's not usually a lot of litigation over this. There's also the outside salesperson exemption. This one is not as widely known because a lot of outside salespeople are working very, very long hours. They might have sales time, or they might have travel time. Within certain categories, some salespeople who are almost entirely doing sales might be covered by the outside salesperson exemption. Now, might be a close call because it depends. Usually people have multiple duties. They do some sales, they do some management, they do some client relations. So this may be hard to apply, but if the person is basically a salesperson almost entirely, then they would be covered by the exemption and they're not entitled to overtime. And typically also a lot of salespeople are going to get pretty high commissions. So if you're a salesperson and you're getting very high commissions, you're probably not entitled to also overtime. But if you are, your commissions cannot satisfy overtime. So the categories are different. Commission is commission, overtime is overtime. So the employer cannot come and say, well, even if we owe him overtime, we paid him commissions, it's about the same. So that's not how it works. The overtime is time and a half of hours worked. The commissions might be based on whatever agreement you made with your employer. That's separate. It's governed by a separate set of duties and obligations. There's also a computer employee exemption under state law. And that is people that are in IT and are doing highly skilled work. They might also, typically, they would also be covered under the administrative exemption or under the possibly executive, depending on where they are in the company. So all of these individuals are potentially exempt from overtime pay. What we want to be careful of is the fake designation when an employer says to somebody who may not have knowledge and call them exempt even though they're not exempt, or just switch them to salary. So we one time had a case, there was chefs, and the chefs were working just extraordinary long hours, and they were told you're exempt. And they took it and they accepted it. But then after many years of working, they realized, oh my gosh, we're working these really ridiculously long hours. We're told that we're exempt, but we have no power in this company. We can't hire and fire. We're just the chefs. We don't get to decide policies. We have nobody working under us. I mean, maybe the sous chefs, but not in any, we don't manage them. And then they realized that it was a fake designation. And it turned out they were actually entitled to overtime for all their hours worked. It is important to note that there are also federal exemptions. We're not going to go into them as much just because we want to just keep an eye on the time. But the FLSA has a few more on top of New York law, and one of the most important ones is the Motor Carriers Act, which is some drivers, if they're driving in interstate commerce, are not entitled to overtime. So you might have people who are, truck drivers or other delivery drivers who are driving very long hours. There are certain requirements, again, certain statutory thresholds. It has to be a certain size vehicles and it has to be interstate. But those individuals will not be entitled to overtime. And also domestic companions in certain situations, individuals that are like home health aides may not be entitled to overtime as well. So these people may be exempt under federal law. So again, if you are in any of these categories described, talk to a lawyer. You may be exempt. And if you're an employer and you're not sure if you're properly designating your employees, also talk to a lawyer, because if you are not properly designating your employees, if you're designated employees as exempt and they're not exempt, you could have exposure for a lot in terms of back wages, as well as liquidated damages. Another type of misclassification that we see a lot is when somebody is misclassified as an independent contractor. And this might happen in startups. Somebody hires a friend and says, you know what, I can't really pay you as an employee right now. How about we'll just, you open up your own corporation. You could be an independent contractor. You'll be independent. And on paper, it sounds like a great arrangement. And the independent contractor believes that they are in a good situation because they're free to, govern their own schedule. And the employer says, I'm good because I don't have to pay this person overtime. Now, if done properly, it could be a mutually beneficial arrangement for everybody, but very often there are abuses in this classification. And a lot of times employers have fake independent contractor agreements that aren't actually independent contractor agreements. And what that means is independent contractor might be the plumber who comes to your house. He or she really, really is fully independent. They make their own schedule. They go on vacation when they want. They can work for anybody else. They don't have any equity in your household or in your business. That is a true independent contractor. A fake independent contractor is somebody that you call an independent contractor, but you designate her schedule, you forbid her from engaging in other employment, she's on your payroll, she can't take vacation without asking you. If any of that is happening, that individual is not an independent contractor. They are actually an employee. And if they're an employee, then they're entitled to all the rights of employees, including overtime, if they're not exempt. So we do unfortunately see this a lot of, just like we have the fake managers or the fake exempt manager, we have the fake independent contractors. And unfortunately, some employers get very clever and they might even have, say, hey, I need you to open your own your own PC or whatever, and we'll pay you through that, and then it'll be better for you. You could be 1099, and we'll all live happily ever after. Again, if they are controlling the relationship, you're an employee independent of what the employer is calling, independent of the title given to you by the employer. The law looks at actually the actual functions. And the federal law has a similar assessment. It uses the economic realities test, but again, very similar factors. Can this person hire and fire? Can they control work schedules, determine rate of pay? All of this is the role of the independent contractor in the business. So if you are an independent contractor who actually finds yourself increasingly controlled by your employer, and you're wondering, wait, what just went down? Then maybe talk to a lawyer or talk to your employer about clarifying. And we'll talk more soon about the very important clarifying all these relationships, clarifying these designations. What are you, an employee or an independent contractor? And if you're an employee, are you exempt and non-exempt, and under which exemption? And if you're an employer, If you want to have independent contractors working for you, you definitely can do that, but just be very careful not to run afoul of the rules and give them almost a great deal of freedom because they are their own, they are not your employees, they're independent contractors. The consequences of improper classification, both in terms of if you're misclassified, like we said before, the exemptions, or in the case of independent contractor, you would be owed what we call back pay. So New York state law, you can go back 6 years. So if you were not paid overtime, so let's say the example of the chefs that I gave. So let's say the chef was paying as was believed she was exempt and was putting in overtime for 6 years. And then she realized that actually it was an improper exemption and she should have been paid overtime. She is owed back wages for 6 years worth of back pay. Additionally, there is liquidated damages, which is whatever she is owed, she gets double because the law says she should have been paid at the time when she did the work. She was entitled to be paid at the time 6 years back, not now. And so the penalty to the employer for violating the law is double damages. So let's say she is owed 20,000, the law will say, well, it's actually 40,000 because she should have been paid that 20,000 back at the time the offense happened. Also, potentially there is attorney's fees and there are also judgment that can be attached to the damages as well. So if you're being misclassified, it may be worth talking to an attorney because you may be owed a lot of money. And if you're an employer and you're misclassifying your employees, it's important that you clarify and make sure that everything is on the up and up, because if you are misclassifying employees, you can have a lot of exposure for a lot in terms of monetary damages. An issue which has very recently been in the news, there was recently a case about Walmart connection to this, is about when you're being paid. So the law says that manual workers have to be paid once a week. They have to be paid within 7 days of which the wages are earned. And in order, what's considered a manual worker is somebody who is mechanic, working or laborer, and they're spending more than 25% of their working time in physical labor. And in recent years, there has been, the DOL has given some advice and interpretation of what this means and some examples of individuals that the employer found, that the Department of Labor found were potentially considered manual workers, were people working in a warehouse, chauffeurs, drivers, hairdressers, pizzeria workers. And part of this reason is that you think about pizzeria workers or hairdressers, a huge part of their job is carrying things, moving around, walking. If you're washing the hair, you're doing the dye, you're doing a lot of actual physical labor. And if it's more than 25%, you would fall within the category of manual worker. And if you're a manual worker, you should have been paid once a week. If you are a manual worker who is supposed to have been paid once a week, and in fact you are paid every other week, you might be entitled to damages. And the trend right now, it hasn't been confirmed on the merits level. It's just been confirmed in initial stage of litigation, but you would be entitled to liquidated damages. So what we were talking about before, so let's say you were paid $500 a week, and you should have been paid, you were paid at the wrong frequency. So you would be owed another $500 for every other week, the weeks that you weren't paid at the correct frequency. And there are employers are right now challenging this in court. As of now, that is a law that's been established. Employers are challenging it, so it may take many years to find out, but as of now, that is indeed the case. And again, the law as interpreted is you should have been paid at the correct frequency. The fact that you weren't, even though you were paid the correct amount, and nobody is disputing that you were owed $500, but the fact that you weren't paid at the correct frequency would entitle you to damages of another $500 for every other week, the weeks that you were paid at the incorrect frequency. The employers are fighting this very much, so this might be sort of duked out in the courts over the next couple of years. Importantly, in this case, just like before, wherever there are liquidated damages, there are typically also, whenever a plaintiff prevails, there's also attorney's fees and interest that accrues over the life of the case. In terms of the manual worker rule, there is a large employer waiver. So if somebody has an average of 3,000 out-of-state employee or an average of 1,000 employees in New York, it can reach out to the DOL and say, look, we have a huge payroll. We want to continue paying everybody every other week. We want this exemption. And the DOL will look at the company and look at their history and look if they've been in compliance before, and will potentially give them the waiver. Returning back to this, if you are a new employer and you may not be aware of this worker, you may not be aware of this rule, it may be worthwhile, if you think there's even a doubt that your business involves manual labor where your workers are spending more than 25% of their time engaged in physical labor, it may be worth it for you to just pay them once a week. You don't lose a whole lot, and you potentially are protecting yourself from potentially huge lawsuits if it turns out that full liquidated damages are recoverable. So if you have been working as a manual worker, you may have a cause of action. You may want to reach out to an attorney. If you're an employer, you may want to change when you are paying your employees and switch it to once a week in an abundance of caution. The New York labor law has established certain notices that are required. And this is very important because New York labor law wants employees to be informed. They deserve to know all of the things we just spoke about. What is their pay rate? Are they exempt? Are they not exempt? How often are they being paid? What is their hourly rate? And so there is a form that upon hiring, an employer is required to give their employee. It's easy to find. It's on the DOL website. And that will set out what all of the details about your pay. Your employer should have given you that, and if the employer didn't, you may be entitled to some damages. If the employer did give it to you, but the information on it is wrong, you may also be entitled to damages. So let's say your employer did give you the correct notice, but it said that you were exempt, and it turns out you're not exempt, then you might be entitled for damages for an incorrect notice. Likewise, if let's say the pay stub said that the wage notice said you're being paid every other week, and it turns out you need to be paid once a week based on the manual labor law, again, then even though you got the notice, it may be wrong, and then you might be entitled to damages. This notice should be in your native language if you do not speak English, and the employer needs to keep it for 6 years. In the example that we gave earlier when we're talking about wait staff, if you're a tipped worker, that should be included in this notice. So this notice should really be a place for you to know all of the details of your compensation. If there's a switch, if you get a pay rate change, then the employer should notify you as well. And the way that's done typically is with a pay stub. Either the employer can let you know with a letter or with a pay stub. Another aspect of the notice law is, so you're supposed to get one when you're hired, and also every pay stub should have full information. A lot of companies do it electronically, and that's fine as long as you can log into ADP and find it. They don't have to give you a paper one, but if you needed to see your pay stub, you should be able to see exactly what was withheld, how many hours you worked, what your pay rate, all of that needs to be fully transparent. If you are an employer and you're not doing this, maybe you're paying your employees in cash, or maybe you're just kind of giving them a check to cash, you should consider changing your practice because you may face exposure. These notices are very important because that's how you'll protect yourself if your employee comes and challenges you and says, oh, I was never paid. These notices will show that you were compliant with the law. So from the employer's perspective, you very much want to be having adequate and accurate notices and pay stubs because it will keep you It will show that you're being compliant. As an employee, the statutory damages, it's $5,000 if you didn't get the wage notice upon hiring. It's also $5,000 if you're not getting accurate pay stubs with each paycheck. And again, even if you're getting them, but they're inaccurate because they say you're exempt and you're really not exempt, or they're paying you at the wrong frequency, or they're paying you at let's say they're paying you at a rate that's improper because it's below minimum wage. Any of those situations would sort of make the notice defective, or the wage notice, the wage notice is upon hiring and the wage statement is with your paycheck. So those are two independent requirements, and a violation of either of them would entitle the aggrieved employee to $5,000 in damages. So a lot of times when one is missing, or when one is inaccurate, the other one is also inaccurate, and the employee would be entitled to $10,000 in damages. So look at your pay stubs, look at your wage notice, and make sure that it's accurate to what's actually happening, and there's no inconsistency to what you're really being paid and what's being put on your pay stub. Going back to the notices, there's one other notice that's required when you are let go. If you've been terminated, upon termination, the employer is required within 5 days to give you a notice stating that you were let go, and that and when your coverage is ending. And again, that's part of the same thing. The law doesn't want, a lot of times people call us and they say, I don't know, my employer took me off the schedule. I never heard from them. I don't know if I'm employed. I don't know if I'm unemployed. That's not fair to workers. If you're going to let somebody go, they deserve to at least have the decency to know that they're let go. And they deserve to have a statement saying, as of this day, this person has been let go. And that's why there is this third notice provision. So you have the wage notice upon hiring, the wage statement with each pay, and then a termination notice upon parting with the company. Again, each of these entitled the employee to $5,000 in damages if the employer does not follow these rules. Also, as an aside, in terms of termination, the employer is entitled to give you everything that you are owed. The employer can't just fire you and say, you know, we're done, and your last paycheck, too bad, so sad, you're not getting it. That would be an express violation of the law, and you would be entitled to damages for that. You may have heard a little bit about this in the news. They're starting November 1, 2022. Employers will be required to post salary ranges in New York City, and that will be something that will be required and will technically or potentially give rise to discrimination if it's not included. This has to be good faith belief. It has to be what the employer believes. Since this is the new law, it might take some time to duke out exactly what compensation, what statutory damages are given, but this is going to be the new law starting November 1, 2022. The salary posting does not have to include other forms of compensation benefits. So if there are some bonuses, if there are other things that are happening, those don't have to be posted as well. And the aggrieved employee or future employee has a private right of action to actually bring a claim for this violation. Another new law that recently was put into practice, May 7, 2022, the New York State requires notice to new hires before engaging in electronic monitoring. There's certain electronic monitoring that is allowed, and that might be just to keep track of what the employees are, certain data collection, what's happening. Obviously, they have to let you know, and the employer has to tell you, look, you know, we have for legitimate business reasons, we have some monitoring. Don't open private things on your work computer. Don't engage in private communications, because all of that is potentially, we have the right to see that. And if the employer does find anything that the employee is doing that is incorrect, the employee can't say, oh, I have privacy rights. So no privacy rights in the workplace. It's a digital world. There's certain monitoring that has to happen, whether it's just for phishing reasons, for other reasons. The employer has a right to do that, but they do have to let you know. So if you're an employee, don't do private things on your computer. Don't engage in any kind of misconduct that can potentially give you that, because that is viewable by your employer. Before we open up the floor to some questions, I want to talk a little bit about paid family leave. Under the FMLA allows unpaid leave, but it applies only to employers with more than 50 workers and employers where you have worked there for a year. Unfortunately, a lot of employees are not going to be covered by FMLA if it's a small employer, or maybe they just started working 6 months ago. The Pregnancy Discrimination Act, which is under Title VII, will cover an employer with 15 or more employees. Again, if let's say you are pregnant and the employer is smaller than 15 workers, you still might not have coverage under federal law. So recently, several years ago, the New York Paid Family Leave Act created a paid family leave program, and this is a very, very good program because not only does it not it doesn't have these requirements of 50. If there's only one employee, the employer would be obligated. So it doesn't have to be 50, doesn't have to be 15. So all employers are obligated to do this. And it's also paid leave. So it's paid leave up to a certain amount. I think at this point it's about 70, 75% or 60 something percent of your paycheck. And the way it works is under this law, employees are entitled to 12 weeks in a 52-week period for what we call a qualifying reason. And a qualifying reason is very similar to what we have under the Federal Medical Leave Act, and that would be to provide care for a family member, to bond with an employee's child during the 12 months of a child's life, and any of the other qualifying reasons under FMLA. What's important about the paid family leave is that in many ways it's similar to the federal, but it has two added advantages. There's no minimum employee requirement, and it is paid. But the way the payment works is paid by deductions that you are putting into. It's paid by deductions that you are putting with each paycheck that you're paying into. So you're paying into paid family leave and then you're entitled to it. So a lot of people do not even know that they're entitled to this. A lot of times we have callers and then we say, well, what about paid family leave? Like, what is that? I didn't know. I thought, that I wasn't entitled. Almost everyone, or I say everyone in New York, except for very narrow exemptions, would be entitled to PFL, to paid family leave. And the way that you would know if you're covered is look at your paycheck. If you see that a deduction is being made by paid family leave, then your employer was actually, you guys were paying into the program, so you would be entitled to these benefits. This is an excellent program. For 12 weeks, you would be entitled to, like I said, I think it's 67 or depending on where the threshold is right now of your salary. Some employers pay the difference. They're not obligated to. So if your employer says, well, you're entitled to whatever PFL covers, you're totally fine and they don't owe you anything. There was one other topic that I did mention in the additional questions, and I'll just cover it really quickly. And it's an important one, and we get it a lot, is the entitlement to bonuses. And this is again, one of the most frequent questions we get, because a lot of times an employer is going to say, look, I'll pay you $50,000, but if everything works out, we have a good year, you'll get a $50,000 bonus. Then at the end of the year, this person gets a $5,000 bonus or nothing. So the rule of thumb is like this. You're not entitled to a bonus unless it's non-discretionary. So a discretionary bonus is, if we do well, if you do well. So the employer is giving themselves a lot of discretion. If we feel like it, if it works, if things are okay, that you have no obligation to that. You have no right to that bonus under the law. So if you are negotiating a package and your employer says verbally, oh yeah, and if we do well, we'll give you $50,000, that's worth nothing. It's just, unless it's in writing, unless it's non-discretionary, it doesn't count. It doesn't become wages. It just is, a verbal hope that the employer gave you that is not really anything you could collect on. A non a non-discretionary bonus is a bonus that is based on certain criteria that, you will get 3% of revenue you brought in, right? It's very objective. It's not discretionary. It's very specific. It's almost formulaic. That you could collect on. That you would be obligated. That the employer would be obligated to give you. So a lot of times, most employers are smart enough now that even when they say they're going to give you a bonus, they include big language in the offer letter that says, but we maintain discretion to change this bonus at any time. By doing that, they're basically taking the bonus out of a discretionary status to a non-discretionary status. No, vice versa. They're keeping it within the discretion. Almost all of those bonuses, like I said, they're up to the employer. They don't become wages. They don't become something you are entitled to under the law. You would only be entitled to it if it's something that is something objectively that it does not depend on. It could vary because it could depend on revenue. So it doesn't have to be a specific amount, but the criteria has to be a non-discretionary criteria. So look at your offer letter, look at your bonuses, and see more likely than not, whatever bonus you are promised is not really a real promise that could be delivered on unless it's ironclad within a contract. And a lot of employees should be careful because unfortunately we give this a lot. We see this a lot. This is like one of the most disappointing things that we hear is that, I started at a low wage, but my employer promised me this big fat bonus. Too bad, so sad. That bonus is not anything that the employer is obligated to give you. So when you're negotiating your contract, you'll say, no, I want more salary. I don't, I'm not going to fall for this fake promise bonus that the employer will not be obligated to give me. So I think we're coming toward the end. So why don't we have some questions? So based on the fact pattern, individual has stated that there is a personal care assistant who has been working for 2 years with no break or day off. She's inconsistent in getting paid. She requested a day off from employer, but was denied for 2 years. So right away, we have a couple of problems. She is entitled to sick time. Whether it's paid or unpaid, it depends on the size of the employer. But even if it was just 4 workers, she would at minimum be entitled to unpaid sick time. So the fact that she's working for 2 years with no break or day off, that is problematic. And this employee does have the right to have day off. If the inconsistent work is also a problem, as we said, the law is very concerned about transparency, consistent pay. When someone is getting paid inconsistently, they probably don't even know their pay rate. Charlotta, this individual that you're speaking about, it may be worth to discuss this with counsel more comprehensively because there are special rules governing the fact pattern that you're describing. So whenever there's a home health aide who has to care for somebody for 24/7, that triggers certain rules because obviously nobody could be working 24/7. So typically the rule of thumb is that if the employer gives you 5 hours break to sleep and 3 hours break to eat, they only have to pay you for 13 hours out of a 24-hour period. This is very important. The employer has to allow its 24-hour workers to have 5 hours of uninterrupted sleep, 3 hours of uninterrupted mealtime, and then they only have to pay them $13 for 13 hours out of 24. If that's not happening in the case of the individual described who's working 24/7, it is worth talking to counsel in figuring out what exactly is going on in this employee-employee relationship and how it's running afoul of some of the wage and hour rules. Plainly, nobody has to work 24/7 for 2 years straight without a break. Certainly not without getting the required overtime. So as to that individual, I do suggests that he or she reaches out to counsel to discuss the situation separately. Another question that came in is, what legal rights do you have if your employer fires you while you're on FMLA leave and does not tell you that you have been let go? This is a really good question, and I'm really glad that you brought it up. Unfortunately, we see this a lot. People go on FMLA leave or other sick leave, and then they are let go. And it's a requirement under both the FMLA and the paid family leave that when you're done with your leave, whether it's pregnancy leave, sick leave, leave to take care of your mom, leave to take care of your kid, when you're, whatever the qualifying reason is, when you're done and you come back to work, you have to be restored to a position of comparable pay. You have to be restored to the identical position of one that's very closely comparable. So if you're fired, or even if you come back and you find yourself in a much more lower position in terms of pay and seniority, you can bring an action for interference or retaliation for taking FMLA leave. The FMLA offers broad protections for anyone that takes FMLA leave, both against retaliation and against interference. The paid family leave has similar protections. They're not as broad as the paid family leave, but you still have those protections. So you should not be afraid to take leave that you need to leave. The law promises you, or provides, that you should be restored to the identical position when you return from leave, and if not, you have a claim for damages. Another individual gave a question of you're working through meal breaks because there's no one to cover you, but being forced to document they took a meal break. Again, this is a really good question. Unfortunately, a lot of employers we've seen this, have an employer will ask you to document something like, oh, say that you took out, say, document that you left for lunch, or even document that you left at 5, but I need you to stay an hour. That is against the law, and you would be entitled to damages for that time. The fact that the employer is creating a fake record, sometimes we see that, doesn't mean that you're not entitled to damages. What you should do in that situation is keep your own record. Make sure you keep your own record. If, let's say, you're working 50 hours a week, but your employer is making you sign a document saying you only worked 40 hours, or you are working through your lunch period, but your employer is making you punch out for lunch. Any of these situations, keep your own records. If in the event that you want to recover damages for those times, you are entitled for pay for the time that you worked, keeping your own records will be invaluable. So in all of those situations, I would encourage you to reach out to counsel. I do believe that on the final page of the PowerPoint slides, there is contact information. If somebody wants to speak to counsel or refer somebody to counsel, that would be the best way to do that. And Pat, maybe you can also advise anyone on this chat, if they did want to have a more substantive follow-up on any of these issues, the best way for them to do that.
Yeah, absolutely. Kaya, would you like to put the last slide of the PowerPoint back
Yes.
up for a visual?
Yes.
And anyone interested in speaking to, Kaya or another one of our employment attorneys, definitely the best route would be via our website, where we would connect you with our client relations team who would gather some information about your matter.
We're very passionate about. Sorry.
Oh, go ahead.
We're very passionate about the rights of workers under employment law and labor laws, and there's so many different nuances and context-specific issues, so we'd love to help you. Feel free to reach out to us so we could talk about your situation at greater length than we were able to cover in this webinar. But thank you so much for joining us. This was really fun, and I hope you were able to learn something new about employment law today.